All right. Welcome everybody to the start of day 2 for IDRA's online conference for 2025. Um, we are IDRA. I'm sure many or all of you know, but IDRA is the Indigent Defense Research Association. We are a collection of academics, government researchers, regulators, practitioners, and many other folks. But all of us are interested in, the advancement of data and research in public defense. I do want to point people that haven't been here to our new website. It's at the same place. It's indigentdefenseresearch.org. But we have launched a completely new website. It has much of the same things on it, but it does have a new section on that is a collection of basically everything we've ever posted as a notable publication on our listserv. So I would direct you to that. It's just the research tab. We do have plans to expand that greatly and have it hopefully be a useful repository of, at least links out to papers or citations for papers for people to use. You can also join our listserv there and kind of, read more about IDRA if you would like to. The only other thing I'll say is the reason we have a new website, among other things, the work of Nicholas Sawyer, a board member, being a large part of it. But in addition to that, we now are a fully incorporated entity. We can take donations. We did a sort of small donation drive last year, and because of that, we have been able to pay for things like services that allow us to have a much nicer website that has more functionality. And so if you would like to donate to that, indigentdefenseresearch.org/donate, or you can just click on a donate link on the main webpage. And thank you in advance, and thank you for donating in the past, that making stuff like this possible. So with that, I will pass it on to our first presenter, Cherise.
All right, well, hi, everybody. Thank you so much for joining this session. I am Cherise Fanno Burdeen. This is only the second or third time I've introduced myself as a doctor. It's very exciting. I just got my PhD, and I am joined today by two esteemed colleagues, but also two of my closest friends, Bloomquist, who's no stranger to this community, and I'm excited to introduce this community to David Kelton Starks, who is a mental health practitioner. And both of these individuals have been in my life for the last several years and played significant roles in my thinking and around this research that I'm going to present to you today, which is the research of my dissertation. So you can read the title. You obviously read the title of the panel. That's why you joined. Or you're here for Riley, who's probably also going to share a lot of wisdom and knowledge with you. But if you're here for her and not me, you just have to wait for about 45 minutes to get to that presentation. That advanced button doesn't work. This one does. So the context of this conversation is around studying cultural competence and client-centeredness within public defense. And in particular, the lens that I wanted to bring to it was an intersection around emotional intelligence. And so I wanted to start by saying that I have spent the last several years, I no longer am, but previous to this, I had spent the last several years working with Ali at the National Legal Aid and Defender Association in the space around public defense. I have spent the last 25 or 30 years working in the criminal legal reform space. And so I've thought a lot about criminal legal reform, and in thinking in the last several years around why it has been so difficult to move the needle in a lot of different places. One place or two places in the last couple of years, I've been thinking around why it's been so hard to move the needle around cultural competence and client-centeredness in public defense. So on the right, you'll see just a sort of laundry list of things that I was thinking about and noticing in this space. And the field of discipline that I just got my PhD in is community psychology. And so this is the lens with which I have been thinking and examining certain aspects of the work around indigent defense or public defense. And so some of the spaces I noticed were interventions that we've been using look at one level at a time. What do I mean by that? So a lot of the things that we've tried over the last decade or so or more have focused on either the individual or policies or practices within the organization, or thinking about the way the organization is situated within the system. But really, these interventions or programs or initiatives have focused on one thing at a time, rather than thinking about all the different levels at the same time. I was also fascinated by the ways in which social work has added a new ethos to our environment. Lots of lawyers, and the law ethos is slightly different than the social work ethos. And so you have these sort of two different groundings around cultural competence and client-centeredness that come from these two different disciplines. It's also a fascinating quirk, professional liability insurance, and something I don't think we think about a lot in public defense, but people think about in terms of also in the medical field, with respect to the fact that when you are responsible and can be held liable individually for the decisions that you make, it often can result in a tension around sort of what I call this sort of lone wolf mentality, where even though you are part of an organization and you do want to think maybe about trying to center the client, there's this notion that at the end of the day, if I can be held responsible for the decisions that I make, there's a tension with trying to center the client's decision making, when I know maybe at the end of the day, legally, I could be held responsible for making the choices that I make. Personal and professional identity development, I think, are also challenges when we think about cultural competence. And I noticed in a lot of the training materials and a lot of the ways in which cultural competence is discussed in the field, there's, and certainly community psychology thinks about psychological components of identity development. These are often under-attended to components of the interventions that we have in trying to advance this work. And you'll see, I noticed sort of in parentheses, this idea of the legacy work of professional identity development. Public defenders have a very strong sort of professional identity as warriors for justice, as fighting for the underdogs, and often have their own individual sense of a professional identity. But there's also this legacy and the history of public defense that comes with being a public defender, and is often contextualized in ways that public defenders have to navigate. You know, sometimes in the client, when there are, I know there's sort of scant literature around the way clients experience public defenders, but the notion of the public pretender is sometimes a professional identity that public defenders have to sort of navigate and push up against. There are also, you know, tensions around saviorism, parentalism, which is sort of a more inclusive term than maternalism, and the power dynamics that exist between clients and attorneys. Those are independent of race and gender dynamics. We have lots of sort of differences, right, between who our client base is and who our attorneys are, both in terms of the vast majority of public defenders are white, the vast majority of public defenders actually are women. And so a lot of this stuff is the soup in which we are actually trying to do cultural competence and client-centeredness, but is often under-addressed in the interventions. And all of this can culminate, and we know that there are a lot of recruitment and retention issues. So just in total, these are just among the issues I was thinking about in trying to unpack why it seems like it's been so difficult to move the needle on cultural competence and client-centeredness. And yet, we know that these are important issues, and we also know that your national standards call for this. Most recently, in 2023, the American Bar Association actually, for the first time in real print, specifically calls for advancing cultural competence. That's principle 7 in this document. And there's another one, principle 9. And I was like, well, do they define cultural competence? And they did not in this document. So I went and looked to try to find a good definition of cultural competence. And I also understand that the American Bar Association's standards and principles and guidelines are the result of consensus-driven conversations. And so while they didn't define it, this is a definition of cultural competence. Principle 9 actually calls for client-centeredness, which has long been discussed in your field. Client-centeredness is a definition from the late 70s. This was not particular to public defense. It's been applied to public defense, but is from Binder and Price from 1977. Obviously, it sort of seems common sense to say that if you center the client's decisions, it will result in higher levels of satisfaction among clients. It's a way to build trust. So these concepts seemed relatively useful and seemed relatively self-explanatory, but also seem very difficult to achieve and seems like things that we've been working on for a while, but haven't been able to move the needle. So why did I want to add, why did I want to add emotional intelligence to this? Because in the reading of the literature, and you will see this if you ever read my dissertation, which I know most dissertations don't necessarily get tons of readership, but if you read in the dissertation, the literature review talks a lot about the unpacking of cultural competence and client-centeredness. And when you look at lots of ways in which the qualitative research talks about these issues, all of the skills that are listed in being culturally competent and client-centered really map onto emotional intelligence. A good definition of emotional intelligence, the ability to monitor both your own feelings and others' feelings, being able to really read and interpret other people, and being able to discriminate among the emotions that people are presenting and your own self, and using this information to guide your thinking and your behavior. This really was made more popular by Dan Goleman and sort of sits in these 4 pillars of emotional intelligence. And I think in particular, I found these 4 pillars to be more useful because empathy as a way of relating and understanding other people's emotions is something that we talk a lot about in the client-centeredness literature. And social work, and I mentioned earlier about this ethos that social work brings into this space, really deals a lot in being empathetic. But we know if we read the literature on client feedback about experiences with public defense, they tend to rate their experience of being centered low, and they tend to rate their experience on what we might call cultural competence as also not very great. And yet when we have also asked attorneys whether they think they're culturally competent or client-centered, even though they wouldn't necessarily give themselves 5 stars, they do tend to rate themselves higher. And so we have this gap between the way clients experience us as a field. I'm not a public defender, but I sort of feel like I'm in this space. They sort of rate us lower and we rate ourselves a little bit higher. And so we have this gap. And so I spent time talking to Allie a lot about, because she's a trainer and a practitioner in this space, sort of what the gap, what's sort of the experience of the gap is. And I will just ask her to chime in a little bit on how chaotic the context is in which you're trying to be culturally competent and client-centered.
Well, and I'm sure these statistics are really familiar to the folks in this room, right? 80% of all the cases, and that's at the low end. There are places where it's higher. 80% or more of all the cases who come through American legal system courts across the country require the services of a public defender. They are overwhelmingly poor people. They are disproportionately Black and brown people based on rate of population. We know all this, right? We know the system is adversarial. We know caseloads in many, many, many places are crushing. Salaries and benefits are low. Retention is low, right? Meanwhile, we're learning and expected to give attention to our clients in a way that centers them, to make sure that we're doing the work we need to do to provide culturally competent, culturally humble services to the communities that we're working in. And the reason I love this work that Cherise is doing, and the reason it really resonates with me, is that this idea of emotional intelligence, this idea of grounding oneself and having some of these skills, it is the lifeline. It is the salve to so many of these challenges. I hear her talking and I think, who are the attorneys? Where are the offices that have the best retention? Where are the offices that have the best recruitment? Where are the individuals who have the most satisfying connection and the best boundaries that allow them to work in ways that don't burn them out? Where does all of that come from? And I'm not sure I really knew the answer until I started working with Cherise and learning more about the relationship between the problems that we know and the pressure cooker that we're operating in, and these things that we often think of as like soft or not relevant to the hard work of trying cases.
Awesome. Thanks, Sally. And, you know, I know that most of us either have children, know children, or have seen children on the street, right? We know kids in public schools in one way or another. So I started thinking about how chaotic the context is for public defense is very similar to the chaotic context of public schools. And in public schools, the under-resourced, the racial disparity between administrators and teachers and public school children often mirrors the experience of clients and attorneys and social workers in our public defense space. And social emotional learning is one of the ways in which school districts try and address the fact that they can't get more resources. They're not going to be able to change the home lives of families. They can't fix the systemic oppression that kids are going through. And so what they try to do is support the teachers and the students in social emotional competencies. And so that's really where I started thinking about the interesting aspect of how could emotional intelligence support ways in which we can raise levels of cultural competence and client-centeredness. Not that it's a panacea, but I thought maybe we could use a refreshed frame inside our own industry. So again, I come from a different theoretical lens, which is the community psychology lens. I was trained as a criminologist originally in the 90s. And for those of you who are old enough like me to remember, I didn't really know this in the 90s because I was only in my 20s then. But there was a time in which criminology really was embedded in sociology, and it was not stripped of its context. And yet my schooling in the 90s really taught me that that sort of crime was sort of this individualistic choice, independent of any kind of system or sociological context. And the thing I appreciate about the lens from my most recent discipline is it sort of really recontextualizes it in ecological systems theory. And so these I'm going to nerd out just for a little bit in the next section. These are the theories that I use. I'm not going to go through them. They're just here for your edification. This is the lens that I brought to trying to think about how to develop my research question. And then some of the outcomes and the ways in which I thought about the implications of my work. So my research questions, I really just wanted to know, is there a quantifiable relationship between emotional intelligence, cultural competence, and client-centered lawyering? And I wanted to know that in particular among white public defenders. And would emotional intelligence and cultural competence predict levels of client-centered lawyering among white public defenders? So I operationalized, I had to think about this for a minute, right? Because I wanted to operationalize client-centeredness in a way that was different. So I chose to think about it through sort of an empowerment lens, in particular because I was trying to combat some of what I was sort of sensing from lots of conversations with Allie and in some of the focus groups we had done for another project, in which a lot of the conversations with public defenders went like this. Oh, I totally center my clients. I absolutely know what's best for them. You know why? Because they're dysfunctional people. If they were functional, they wouldn't be in the position that they're in. So no, I don't have to ask them what they need. I know what they need. That's very parental, and that is very savioristic, and that is not client centering. And so could I think about how would I operationalize this in a more empowerment centered way and less about the lawyer and about the lawyer's expertise? And I operationalized cultural competence as anti-racism, and I did that for a very specific reason, even though the American Bar Association did not. Obviously, there's the issue of systemic racial dynamics in the criminal legal system, but 70, and Allie's absolutely right, Black and brown people are overrepresented in the arrested population, but 70% of arrestees in the United States are white. So I still needed to be able to say and defend the fact that I was operationalizing this as anti-racism. I chose to do that because anti-Blackness is one of our founding cultural isms, and starting there teaches you skills to be able to see other systemic issues. Ageism, which is something I have recently begun to experience, and ableism, which is something I am woefully inattentive to. And I wanted to investigate emotional intelligence. Again, a little bit of nerdy stuff. So my quantitative work was in correlation. I used some standard instruments, which I'm going to show you in a minute. And I did a qualitative focus group with trainers of public defenders. And it was a mix of people who are embedded in organizations and therefore train people that they live and work with on a daily basis. And some were national trainers who go around the country doing training. If you don't care about this particular slide, you can just focus on the musical instruments on the left side of the screen and think about the kinds of things you like to play. Otherwise, you can look at the nerdy stuff on the right. Those are the instruments I used. I did some social desirability testing in there. The second one is a emotional intelligence standardized test. It's a short form. The third one on there is the anti-racism behavioral inventory. And the client-centered lawyering one, you see my name because I made it up. I made it up from qualitative research around what clients want from public defenders. I made up an instrument and then did reliability and validity testing on it, and it passed all those tests. And then this just gives you you can read it for yourself, but on the right is a profile of the sort of average participant. And yes, with a few exceptions, the average participant in my study was Allie Bloomquist, with just a few exceptions on that list. And interestingly enough, also separate from my study, if you look at the average the literal average public defender in the United States of America, it is the average participant in my survey. So that was actually kind of cool. So my paper also has all of the other things you would normally see in a very research-heavy presentation, but that is not what I am sharing here today. Here's my bottom line up front, which is that there was a positive and statistically significant relationship between emotional intelligence, anti-racism, which was my proxy for cultural competence, and client-centered lawyering. As I tell my son all the time, your mother is always right. And so here, the data bore out that Cherise was correct. I was really thrilled about this. I wasn't sure, but turned out there was a positive and statistically significant relationship. But what was actually even cooler was that emotional intelligence and cultural competence actually predicted client-centered lawyering, with emotional intelligence actually being the stronger predictor of client-centered lawyering, with cultural competence actually adding something unique to the model. So this was cool because it allowed me, prior to the focus group, to think about ways in which I could talk to the trainers about what they were seeing in their training experiences, and think about what this might mean for the future. So I'll just run quickly through some of the cool parts of the focus group. So I went to the focus group with the trainers, really trying to unpack not just the standard things, I think, that I already kind of expected from lots of other qualitative pieces of research about the experience of trying to train, in particular, white participants on anti-racism and cultural competence and sort of person-centeredness, in this context, client-centered lawyering. And so that's really what I went into the focus group attempting to do. And then there was a little plot twist, which I'll tell you about. So these are some of the major themes that came out of the original intention of the focus group. Yes, people kind of, the trainers noted, yeah, we sort of know about these concepts even before the ABA put them in their document. But they're kind of illusory, like these are known, but we talk about them, they're kind of reactionary and symbolic, especially after the murder of George Floyd in 2020. We did a lot of talking about this. People developed a lot of like, oh, we have to suddenly develop training on this. We need to like make sure we talk to our staff about this and develop all of this. But it was really not, it wasn't very deep, and it really didn't stick. The second theme was that, you know, as you might expect, and as we've all read about in lots of different, from lots of different sources, participants in trainings are dismissive of the content. They confront the trainers with statements indicating that they don't need this kind of training. They already know this stuff. They are already culturally competent. Statements like, I don't need training on cultural competence. All my clients are Black. I obviously know how to talk to Black people. Or I already know all of this content. My clients love me. Really not having any quantitative data to back that up. Or they're, you know, the emotions get triggered, just things that we have sort of over the last 4 or 5 years just dumped in a single bucket called white fragility. But the major theme really is that much of this training on what Ali sort of described, or we tend to lump into this bucket called soft skills, which is often funny because I sort of think of these as sharp edges of people. So I don't know why they're soft skills. Really confront people's views of themselves, and that defensiveness kind of raises its head in these conversations. And the third is that really all the trainers felt like some kind of more transformative change was actually needed, better training, real commitment from leadership, and that these can't be sort of standalone trainings on cultural competence or client-centeredness, that all of this stuff really needs fully integrated, and that every single training that is done on any topic should include themes and be grounded in cultural competence and client-centeredness. All right, my colleagues kind of missed this really cool image, but I was like, trainers EI, get it? Those are trainers. Trainers EI. Oh, God, I thought it was so cool. So the kind of plot twist that happened during the focus group was that as I was having this out-of-body experience. So as I'm watching the trainers talk, all of a sudden I'm sort of noticing that the trainers themselves are displaying varying levels of EI. As they're talking about participants, as they're interacting with each other, as they're interacting with me, I could hear in their responses to my questions, I could hear in their descriptions of participants, like varying components of emotional intelligence. And it started to sort of dawn on me that the way they responded to participants, the way they responded to their organizations, and the ebb and flow of their organization's commitments to these things made me think about how the emotional intelligence of trainers and the people we asked to lead efforts on cultural competence and client-centeredness actually matter for the very moments in which the trainees display the kind of pushback or low emotional intelligence that we actually should come to expect. And so I started to think about and unpack pushback in those trainings and the importance of the trainer's EI. I don't know if anyone's ever seen this slide before, or this concept. It's from Kelly and Connor from way back in the day, but the emotional cycle of change. So why should we actually expect sort of dips in emotional intelligence from people during cycles of change when we're asking them to take on something difficult? You know, the systems and structures that we live under benefit really kind of a small number of people. If you can shut down Venice for your wedding, then the systems benefit small numbers of people. And the emotional dysfunction we see, which is not just this lack of social awareness or self-awareness, but trouble accessing empathy for certain groups or situations, and the proliferation, I think, of anxiety and depression in the general population. This is all the logical consequence of stuff we're living in. So we often have this kind of reaction to it that we sort of shame it or think we shouldn't experience it in other people. But there is this emotional cycle of change. And if we can get people past this little valley of despair at the bottom and view this resistance as energy, not enemy of change, with a little hat tip to Jamie Washington, who's the author of that statement, we can make some progress. So I think expecting people's emotional reaction to conflict and discomfort, and for this part, this is really where this deep emotional intelligence work comes in. I'm gonna pass it off to David to sort of dip in and talk a little bit about people's responses to conflict and discomfort.
So what we're looking at is nothing new. Everyone has seen these common responses to conflict or confrontation. And it's not necessarily looking at them even through a new lens, but maybe just from a different angle. If we were talking to public defenders, then one of the two that I'm going to talk about today that I would have picked would have been fight. But we're not. So what really comes to mind out of the two that I want to talk about for just a really brief moment, the first one is freeze, right? Because in a high stakes environment of professionalism, oftentimes making the wrong decision can lead to disaster or at least a disruption in someone's career. So freezing becomes one of the options because fighting and fleeing are not. You're a professional, you're there, you need to stay. So freezing can often be disguised as thinking or considering or deliberating and trying to figure something out in a way that's going to be helpful. And it's just a way of putting off the immediacy of that conflict and that confrontation. But really where I want to bring your attention is down to friend. Because oftentimes friend feels like a really accommodating way. It feels like we're really meeting someone halfway and building a bridge. But I really want to focus on the fact that actually the friend is often a way to offload or shift responsibility, and can be very manipulative. So we really need to look at that. Instead of it being an attempt to appease or to align or even to find, like I said, a way to build a bridge, it oftentimes results in something very negative, such as a loss of authenticity, the inability to be creative or an effective leader. So as you all look at this and you look at your own experiences, think for a moment, how do these two particularly show up in the work that you do? How do these show up in the way that you deal with conflict, the way that you deal with confrontation? And particularly under friend, really look and see, do I use that modality? Am I using this in a way that, even for myself, I'm convinced that this is a positive way to deal with things? And is there something else underlining that I should take a look at? If anybody wants to give an example of that, you can have a quick second to do that. Back to you, Cherise.
Yeah, there was an example from the focus group where one of the trainers reported that what she called sort of this magical exemption, which is in the cultural competence space, someone saying like, oh, I just can't do it. Like you have some magical dust and you are amazing. And so I can't handle anything. Like I don't know how you do it. You're great. Like I don't have what you have. You have some magical dust. It reminded me, if anyone saw that movie, I'm going to butcher the title of it, but it came out last year. Something about the magical Negro. It was such a great movie. If someone remembers the title, they can put it in the chat, but it was hysterical. And it's a great parody on sort of the way in which white people wait for the magical Negro to show up and make everything okay. Thanks, David. I appreciate that. Yeah. So, obviously all studies have limitations. And I think we wanted to go through kind of that ways in which people express conflict, like kind of deal with conflict, because the emotional component of all of this feels like ways we're not supposed to talk about at the office. And yet we all talk about it behind the scenes about people at the office. And so bringing this stuff into the light, I think, is really an important way to move forward in thinking about the ways in which we should be talking about how we're bringing our entire selves into the space and how that impacts the work that we do. I think in any study, when people see the title of a study, I think there are plenty of people who are excited about that particular thing. I wondered why nobody got kicked out of my study because of because they failed the social desirability things. And yet I still think that there were many people who answered the questions in my survey in ways in which they thought they should have answered those questions. And there's like no good way, I think, in research to really control when you're asking people about tough questions like this. I still think you're going to get people who are going to answer questions in more positive ways than they really believe, but you still do the best you can. And then I did develop my client-centered lawyering survey from client research, but I didn't have the opportunity to validate it with clients. So that's one thing that I would do in future research. So some implications. I mean, I think that one thing to take from both the quantitative and the qualitative research is to say that emotional intelligence, I think, is it's more important than we thought it was. We knew it was important, but I actually think we have focused so intently on trying to address cultural competence directly, especially in the aftermath of 2020, that I think stepping over the emotional intelligence component is sort of like building a house without building the foundation first, and trying to build a house without building a foundation first. So I don't think it's an asset. I think it is a starting point. And I also think that focusing on the emotional intelligence of the people we put up in front of these rooms is also really important. I think that there are really important components. And in my paper, I talk a lot about like peer recovery models. There are important, I think, lessons to learn from the recovery community around mentorship and around people supporting people with lived experience in sort of in their own emotional healing journey, being able to support other people who are going through sort of EI skill building. I'm not talking about doing therapy at the office. I am talking about trying to build emotional intelligence skills and working with people who've also been on that journey and may just be farther ahead than you. And the importance of our trainers and leaders having a high EI.
Cherise, can I jump in 1 second? I also think what this sort of in the totality means is that thinking about hiring competencies that are associated with EI is also really, really important. And understanding what that even means, like how, someone who's new to this, even if I'm practicing high EI, if I don't have a vocabulary for it, I may not be able to identify it in other people. I may not know what that looks like.
Yeah. Thank you. Yeah, and so same, the implications and the recommendations are sort of the same. Like, I think you got to focus on who you hire, how you develop core competencies, the measurements that you can put into place, and really sort of thinking about these inside the context of developing personal and professional identity development work. There's some good future research I hope to be able to do. I hope to partner with people to be able to do, or I think other people can do. The number one thing would be for me or others, I think that if there's any organization out there that would be willing to sort of like do it as a whole organization. I did it across the country with people from lots of different offices, but I would love to find a single office and work on doing some survey work within that single office, and also some sort of designing and testing some interventions within that office. I think that's my last slide. Well, my last slide is really this one, which is that last year I founded a nonprofit with David, and Ali's a founding board member. And so this is the kind of work we're trying to do through that organization. So should anyone be interested in working with us, that's where you can find us, at IDEIA.org. So I know we now have 4 minutes or 3 minutes left, although I ceded 3 minutes to Torin at the beginning of the conversation to administrative housekeeping. So any questions you have for us, we'd be happy to answer. Or you can, I'll put my email in the chat as well. I'd love to ask or answer any questions.
I will say there was also a request for your dissertation, if that is shareable. Yeah, I know you said that.
So my dissertation is going to be published this weekend, and I'd be happy, and I hope that IDRA would be willing to put it in its latest publications list.
Yes, I was going to say that. Please email me or Vanita Embry. You have my email already, but if you have Vanita's.
Yeah, absolutely. And this is being recorded and will be shared.
Yes, correct. Yes. I have a question that I'd like to ask while the questions kind of rev up. So I'm not very familiar with a lot of the literature that you are kind of building on top of. I have a background long ago in kind of the cognitive psychology field, and in that there's this kind of concept that I think emotional intelligence was originally kind of an a analogous concept where, there's kind of like this general intelligence that affects a lot of tasks. And then there's also task specific intelligence. And in that literature, and I think some of that literature may not be the way to go about it, but I just wanted to ask about how, like, what's your optimism on the ability of like training something that seems like as domain general as emotional intelligence? Because in that field, they basically, there is very little training of that kind of general level of ability that affects all these different tasks. They can train people on individual things. Like in this example, I think cultural competency might be a thing that might be easier to train than emotional intelligence. And maybe I'm wrong on that, but I would love to hear your thoughts on comparing and contrasting training those two, and if you know anything about like previous attempts to like really get at bringing people's emotional intelligence up, and how effective that's been.
Ali, did you look like you were like chomping at the bit?
I mean, I would love to contribute to this, but if you want to start us off, well, no. I mean, you're not wrong in that it's not like we could just be like, here's your training and now everybody's, emotionally competent. But I would push back against the idea of this sort of general domain and not tying this to very specific tasks in the work. So, client interviewing with a lens towards EI competencies looks very different than client interviewing without that piece. And so you're building skills into that exercise that are high EI, high emotionally intelligent, strong regulation tools, like all the things that you need for that intake. What we need to be thinking more purposefully and intentionally around, what do we mean when we say wellness? Well, one of the things we mean is helping people feel emotionally regulated in the work. So that means we need to talk to you about the fact that coming into contact with clients in their lives, and these stories and these systems are going to cause emotional reactions in you. We have to really be explicit, I think, about talking about that and providing support through managing that, so that people start building higher skills around that. It's obvious in the case of, cultural competence. How do I regulate the feelings of, whoa, I'm not anti-racist. That's not me. How do I regulate that in the moment so that I can hear the feedback, learn the new skills, incorporate that into behaviors that actually do reflect my internal feelings of who I am, which is not anti-racist, right? All of these are like very specific skill-based exercises and trainings and conversations that have to be embedded across the entirety of the practice and across every single role that is both internal and client-facing.
I'm just going to leave it with Allie.
Yeah, that's a very good point. Kind of taking those very domain specific things and kind of letting that feed up towards the general. I think it's a great way to look at it.
I guess the one piece I will add,
Sure.
which I didn't emphasize a lot of in my presentation, but in my paper I do talk a lot about sort of the companion, which EI literature does not do, but I do, is add in this piece around personal identity development work, which is also in psychology, which is and we do some of that in the anti-racism work. You look at your privilege wheel and you like think about your person, but in that space of really unpacking sort of your personal identity is also a component of emotional intelligence. Like you really have to combine the two and understand like, who are you, so that in your self-awareness and your social awareness, like that's an important component when you have the power dynamic and the race dynamic and the gender dynamic between. And I think this just, to me, there's so much about this that is such a nice handoff to Riley's work, because in this space, like all of these dynamics live and impact so dramatically the harm that is caused in the family court systems. And so with that
was a way better transition than I could have done. Please go ahead, Riley.
Thank you so much for that. And that was a
You're
phenomenal
welcome.
presentation. Yeah, and congratulations on finishing your doctorate. That's amazing. Okay, let me share my screen. Okay, good afternoon, everybody. Thank you so much for having me. My name is Riley Weinstein, and I'm the Family Court Senior Research Associate at the New York State Office of Indigent Legal Services, ILS for short. And I am very excited to speak with you today about strengthening parent representation in family court for parents facing child welfare investigations and allegations of child maltreatment. And the focus of today's presentation is on the early data insights that ILS has gained through a very new and still developing family court data reporting process. And to give you a little bit of my background, in addition to my role at ILS, I'm working on my PhD in social welfare with a focus on systemic change in the family regulation system, otherwise known as the child welfare system. And before shifting to a research focus, I was a clinical social worker within the New York State foster care system. Thus, I come to this state level work of strengthening parent representation with experience of how the systemic failure of poor quality legal representation traumatizes and harms families, and who are disproportionately Black, Brown, and due to historical and current structural inequalities are gridlocked into poverty. And on the flip side of that, I believe that quality legal representation can help protect parents' rights and connect families to much needed resources to support their legal and extra legal needs. Across the country, indigent defense conversations often center on criminal legal systems, and rightly so. But as I kind of alluded to in the last slide, there's another critical arena where people's rights, liberties, and family integrity are at stake. And that's in family court, specifically in Article 10, abuse and neglect proceedings. Every year in New York State, thousands of parents risk losing custody of their children due to state intervention, which in New York is Article 10, abuse and neglect proceedings. Just like in criminal court, these rights are at stake often during times of profound personal and systemic crisis. Also, just like in criminal court, the quality of representation can profoundly shape parents' experiences and the outcome. Yet, parent representation, particularly in the context of child abuse and neglect proceedings, has historically received far less attention, funding, and data oversight than criminal defense. Unlike many states where parent representation is limited and provided only at later and more severe stages of the court proceeding, for example, the termination of parental rights proceedings, New York guarantees financially eligible parents the right to counsel at every stage of the family court involvement for abuse and neglect proceedings, from the first court appearance through the appeals process. This expansive right to counsel is a powerful foundation for family defense. But historically, the system has operated with minimal infrastructure to track the quality or consistency of that representation. In 2006, under Chief Judge Kaye, the Commission on the Future of Indigent Defense Services wrote a report on the widespread deficiencies in New York's criminal indigent defense system, but excluded family court, even though many of those same issues were and are present in family defense. In criminal defense, New York has made major progress after the Harrell-Herring settlement in 2014 and its statewide expansion in 2017, which imposed a binding court mandate requiring systemic reform, increasing state funding, developing caseload standards, and a lot of data reporting. In contrast, the family court reform started later and has gone more slowly, but it started with after the Commission on Parent Legal Representation's report to Chief Judge DeFiore in 2019 formally recognized the crisis in family court and called for the state to take action to address the systemic failures, particularly for parents in child abuse and neglect proceedings. This report led to the creation of the ILS Family Court caseload standards in 2021, and also may have impacted the subsequent annual increases in New York State funding for parent representation quality improvements. Notably, unlike criminal defense, family court parent representation reforms do not have a comparable court-ordered mandate. Therefore, progress in family defense depends more on state legislative funding, agency leadership, primarily by ILS, and collaboration with county-based providers in a county-based system. With the steady increases in family court funding, ILS has taken a central role, issuing competitive grants, developing model offices, and creating the state's first coordinated family defense data reporting system. And as I mentioned earlier, this system is young, but it is growing steadily. This visual here shows how the state investments that I've mentioned have really, truly grown since 2019, not only in total dollar amount allocated to parent representation, but also in the number of counties receiving this dedicated funding through ILS's competitive family court grants. So over the years, we've seen sustained expansion that continues to build the statewide infrastructure that the DeFiore report called for. And currently, a total of 41 New York State counties plus New York City, which is 77 provider offices altogether, are receiving dedicated funding in the form of competitive grants issued by ILS. These state investments have done more than just increase the funding. They've also created this opportunity to collect standardized semi-annual data from grant recipient providers across the state for the first time. So today I'll share some of these early insights from the data, which ILS receives via a report called the Parent Representation Report, or PRR 195. We love our acronyms in state. So I'll be discussing both the meaningful progress and persistent challenges as we work to strengthen parent representation and ensure that parents receive the robust, high-quality defense that they deserve. And lastly, we'll explore the ways in which data can strengthen parent representation as it has done for criminal defense. The parent representation reporting requirements were developed over the course of about 18 months in 2023 and 2024. As a part of the process, we at ILS had individual data collection meetings with each grant recipient to determine their data collection capacities and appropriate metrics based on their grant-funded projects. We consulted with the Parent Representation Advisory Council, a group of county-based leaders in parent representation in New York, to create definitions for reporting. ILS received its first PRR 195 submissions in August of 2024. We received 31 of 33 anticipated submissions, and we attribute this high response rate to the consistent data outreach and preparation that we engaged in with providers throughout the initial development process. And notably, the August 2024 PRR 195 was unique in that it was a cumulative report covering implementation start through June 30th, 2024. Implementation start really varied across providers based on which round of the grant funding they had received. If you remember the bar chart, each year additional counties received grant funding. So this cumulative report allowed providers to, first of all, practice reporting on this new instrument and on new metrics that they never reported on before. And it also provided ILS with an overview of implementation to date. In contrast, the most recent PRR 195 covers calendar year 2024. While it is the second PRR, it is the first to provide annual data, which allowed for the first family court caseload analysis. And moving forward, the PRR 195 will have fixed semi-annual reporting periods, which will eventually allow for year-to-year comparisons. In this latest calendar year 2024 report, which will be the focus of today, there were 51 grantees, about 3/4 of which were institutional providers, and about 1/4 was assigned counsel programs. We received in this last report 45 of 51 responses. The submissions that we didn't receive were from providers who were experiencing implementation issues and delays. And now I'll kind of shift into discussing the results of the PRR 195. While New York State does not statutorily guarantee representation before a petition is filed in court, ILS grant initiatives aim to expand timely access to counsel by providing legal representation during the Child Protective Services, or CPS, investigation phase of a case. This type of representation is called investigation representation, or IR. In 2024, about 65% of the grantee providers were focusing on providing IR as a part of their grant-funded initiative. Of those IR-funded grantees, about almost 3/4, 73%, reported closing investigation representation cases in 2024. And you can see the totals reported here. There were 1,884 opened, 1,682 closed, and about 433 pending. There were at least 1,420 clients and at least 2,161 children. And I say at least because some providers indicated in their report that they were still in the process of ramping up their data collection in 2024. So the total number of children and clients here reflect the minimums represented, but may not have accounted for example, every child that was involved in the CPS investigation. For the IRs closed, outcomes were unknown for 22% of the cases. And based on anecdotes and provider narratives, the unknowns here may be a result of losing contact with the client or the client getting representation elsewhere, but we can't say for sure, of course. And additionally, an abuse or neglect petition was filed in only about 7% of the IRs closed. Of the petitions filed, the vast majority, 96%, were neglect petitions and just 4% were abuse petitions. And as a growing body of scholarship acknowledges, neglect petitions are often closely linked to poverty and material insecurity. So 96% of the petitions filed being neglect rather than abuse makes sense for the demographic of assigned counsel eligible parents. It also highlights the need to address these poverty-related causes of alleged child neglect. No petition was filed and 70% of the IRs closed. However, no court intervention at that moment does not equal no consequences for clients. In the absence of a petition filing, an indicated report still can have dire consequences for parents. For example, job loss, inability to obtain employment, and implications for housing and custody decisions. Eventually, the goal for ILS data reporting is for providers to be able to identify when there is an indicated report, even when a petition has not been filed, as this will paint a more complete picture of the case. In an effort to understand the totality of IR client involvement in legal systems, we asked providers to report whether IR clients had concurrent matters pending in family court and/or criminal court, whether these matters were related or unrelated to the CPS investigation. About half of the IR implementing grantees were able to provide some data on IR clients' involvement in these in family court. And consistent with results from the first round of the PRR 195, custody and visitation was the top petition type pending for IR clients, followed by family offense and modifications. A little less, about a third of the IR implementing providers reported on IR's clients' involvement in the criminal legal system. Also consistent with the data from the first round of the PRR 195, misdemeanors and violations were the most common pending criminal court matter, followed by nonviolent felonies and violent felonies. Due to missing and incomplete data here, we can't yet provide descriptive statistics on the true overlap numbers for IR clients in family and criminal court matters. However, this preliminary information suggests that parents under CPS investigation are often undergoing multiple legal proceedings in both family and criminal court. And this multi-system entanglement, again, underscores the need for the interdisciplinary model of representation, which enables defense teams to connect clients to concrete resources and coordinate family court representation with criminal court proceedings when applicable. As with any implementation in a county-based system, there are cultural and systemic barriers to creating change. In the first and the second rounds of the PRR 195, a thematic analysis of provider narratives on barriers to IR yielded these top three barriers to implementation. First is a lack of public awareness. The community is generally not aware of their rights in a CPS investigation, nor are they aware of the availability of legal services for investigation. Secondly, a lack of cooperation from the local Department of Social Services. Many providers engaged in negotiations and continue to engage in negotiations with the local Child Protective Services / Department of Social Services in an attempt to get notified of investigations and potential referrals in real time. Based on provider narratives, this appears to not be happening as much as was hoped or envisioned by providers. And the third barrier is a lack of staff to provide investigation representation. To me, all of these taken together, the implications here are for a robust public outreach campaign, which of course necessitates additional funding, resources, and staff. Relatedly, I think that another conclusion that could be drawn here is that relying on cooperation from the Department of Social Services may not be a reliable means of getting referrals for IR, which again points back to the need for more community outreach. Okay, so now I'll get into the next section on the use of specialized services. Given that client needs tend to extend beyond the Article 10 proceeding, as I've discussed, interdisciplinary representation is a central component of the ILS Family Court grant funding. Generally speaking, interdisciplinary representation is a model that, again, integrates those specialized service professionals like social workers and parent advocates into the defense team. And it emphasizes the utility of retaining other types of interpreters, experts, and investigators. Most grantees, about 86%, included specialized services in their budgets and work plans under the ILS grants. For assigned counsel panel grantees, the funding is most frequently in the form of contracts and consultations. For institutional providers, the funding is most frequently in the form of personnel or in-house positions. But about 18% of institutional providers have both in personnel and consultant funding for specialized services. As of the end of 2024, about 64% of the full-time equivalent positions were hired for specialized services. Now, taking a look at this chart, we can visualize the percentages and types of specialized services utilized on the IRs and Article 10 and termination of parental rights petitions closed in 2024. And just as a note, this chart includes both grant-funded and non-grant funded specialized service professionals. Results showed that that paralegals and social workers / case managers were the most frequently utilized type of specialized services across all representation types listed here. Paralegals and social workers, as well as specialized services in general, were more frequently utilized in IR compared to the petition representation. Looking at the fact that these are the two most frequently utilized professionals, I did begin to wonder about the overlap and also the distinct ways in which providers are utilizing paralegals compared to how they're utilizing social workers and case managers during representation as part of the defense team. After reviewing the content of 22 provider narratives on the use and value of paralegals and social workers, the following kind of emerged. Paralegals and social workers / case managers are distinct roles, but there is a meaningful overlap in practice, especially in client communication, documentation, and coordination with outside agencies. Paralegals focus on the legal and procedural tasks like drafting motions, organizing case files, assisting with discovery, and sending reminders to clients. Social workers and case managers, on the other hand, address clients' social and practical needs through assessments, referrals to things like housing and treatment. They engage in follow-up and advocacy with the Department of Social Services and other service providers within the community. While their focus differs, legal versus social support, their work often intersects. I think it would be valuable in future research to explore this cross-functionality more deeply. But for now, it's clear that providers view both roles as essential during the investigation and petition stages of representation as they strengthen client engagement and the overall defense. Now transitioning into the last section of the results, I'll move into discussing family court caseloads and the first PRR 195 caseload analysis. Before we dive into the results of the caseload calculations, I'd like us to just keep some very important context in mind. While we at ILS completed a rigorous review of the data and follow-up with providers, we have to remember the limitations of the data, which are that first of all, the analysis does not include assigned counsel program caseloads. Additionally, it is missing about 22% of the institutional provider caseloads due to a lack of sufficient data and ability to report in all the caseload categories or a sufficient number of the caseload categories. Additionally, providers are self-reporting in the aggregate, which means we cannot confirm adherence to the reporting guidance and definitions that we provided, although we do what we can to promote it. And we also don't have data from previous years that would allow for comparisons between years and also offer that further verification to see if there's a huge increase or decrease. While I may Although I may say, all of this, it's also true that providers reach out in advance before submitting their report. They ask a lot of questions. They double check that they're counting correctly. So all of that does boost my confidence in the data. I also want to highlight that to date, the funding available through the ILS Family Courts grants is modest. It's less than 28 full-time equivalent attorneys, and based on estimates we've conducted, 28 full-time equivalents is not nearly enough to meet the level of need for most family court providers. So all of that is to say, the goal of calculating family court caseloads at this point is not to assess compliance with the caseload standards, but rather it's to quantify caseload need. So the following results are based on data from the 28 institutional provider grantees. The results of the calculation showed that less than 1/5 of the providers reported caseloads below the recommended caseload limit, which is 300 weighted petitions per attorney per calendar year. Over 2/3 of the providers reported caseloads at least 2 times greater than the recommended caseload limit. Over 1/3 reported caseloads at least 3 times greater than the recommended caseload limit. The median caseload was 759 weighted petitions per attorney. In other words, 2.5 times the recommended caseload limit. As a visual representation of the institutional provider caseloads, we can see here that the most common caseload range was between 601 and 900 weighted petitions per attorney. So again, a range from double to triple the recommended caseload limit. So overall, the first round of caseload calculations adds further quantitative evidence to what the DeFiore report highlighted in 2019, and also what so many practitioners report anecdotally about the exceedingly high family court workloads. In conclusion, the results of the PRR 195 suggest a promising foundation for family court data collection. And from a data perspective, I did see some improvement in reporting in terms of completeness and accuracy for providers who are reporting for the second time compared to how they reported for the first time. I was also pleased to see that as many as 3/4 of the institutional providers were able to provide sufficient caseload data. And those results, again, really underscore the need for continued state investment in parent representation improvement. Additionally, provider narratives in both PRR 195 reports emphasize the centrality of specialized professionals like social workers, case managers, and paralegals to holistically address clients' needs, which are inextricably tied to their legal troubles. Moving on to next steps. So the next PRR 195 is due in a month on August 1st, and it will cover the first 6 months of 2025. In the next annual report, which will be in March of 2026, 27 new grantee providers from 15 counties, new counties, will begin reporting. That will be added to the list of reporters on the next PRR 195. Future rounds of grant reporting will also provide opportunities for further data verification and comparisons of the results by year and by provider. And as always, ILS will continue to help providers troubleshoot implementation issues and bolster data collection capacity. So that brings us to the end of my presentation, and I would be happy to take any questions that anyone might have.
There was a request in the chat for your PowerPoint slides, if possible, if you want to. I mean, so your email is in the program, but if you want, you can drop it in the chat if you would like to share directly. Or
okay, no problem.
I did have a question while we wait for more to come in. So on the I'm sure you know every state, it seems like, especially with family court, has like different words for every step of the case. So the IRs um, can you give me an idea of like how, if a case is an IR, that means like CPS is investigating, right? Is that a fair? And then how long will a case typically be open before a petition is filed? Is it like weeks or like a year or?
Yeah, you're touching on a really important point, which we ran into while we were creating our definitions for reporting. It, like you said, it varies county to county. It's supposed to be over within a month or 60 days. So our reporting definitions, I believe they cut off at 60 days, just for the sake of being able to report data. And then we have definitions for when it's a new IR, you know, you would open a new one instead of continuing the maybe a previous one. But yes, all that is to say is it was complicated to define our terms.
Okay, so if a case proceeds beyond an IR and it gets filed, presumably there's a significant amount of time before that case is closed still. Like that's kind of the first step of a case in New York. Is that right?
Do you a long amount of time before the petition is closed, do you mean? Or
Yes, the petition is closed, yeah.
Yeah, typically that seems to last, that can be years.
Okay.
So yeah, it's a long-term thing.
Yes, so that's all of that was background for questions I had. So, and I think your answers to this may be sort of, so I was going to ask, like, do you know how many cases are not receiving that investigative representation? And it sounds like the definition is maybe just not clear enough to even, like, this is kind of your definition that you're operationalizing, and it's not something that like the state as a whole collects statistics about. Is that right?
Exactly. Yeah, on a state level, we really don't have that data. So this is the first time that we're even asking the question. And we are only asking the question to the grant funded recipients, many of which are implementing it. But as a kind of a baseline, it's not widely happening, the IR. Yeah.
Okay. Do you know, or do you know if you'll be able to have data from like the CPS side on how often their investigations become petitions, like filed petitions?
There is some publicly available data on that.
Okay. Do you know if the IR, because from what I recall, the IR results were quite good, right? It was something like was it 70% of cases, something like that, were not filed. Because that could be like a really killer, you know, if you can compare that overall versus just the IR people.
Exactly. I'm thinking about the same things. It would be great, especially one day, to, you know, get into the case level analysis and looking at, you know, IR's impact on the outcome of a case. And that, you know, we're not there yet, but that is definitely where I would love to see us go.
Yeah. It's super interesting. Indiana is coming at the same kind of problems in terms of getting people involved earlier. And it is very, we don't, depending on how it's defined, you know, I would have to like think about what our equivalent to IR is. I think we have some people doing some equivalent to IR, but it's just because the right to counsel attaches very slightly earlier. So, but in terms of like actual, you know, pre-petition work, generally it's very rare here. So I'm super interested in this as a topic. It's something we've been trying to pilot as well. But yeah, I definitely want to open up the floor to any questions about either of the presentations today, or if the presenters have anything additional that they would like to add or kind of have dialogue about. So I'll pause for a minute just to let that potentially happen. We're also, you know, we are allowed to end the session early. That's not a problem. All right. Our next session is at 2 o'clock. So about 20 minutes from now. So I would love to see you all back there. And if you guys have any closing words, I'm happy to hear it. Otherwise, we'll sign out. And thank both of you. These were great presentations, and area that I think is very important, and I'm also very personally interested in. So thank you both, and we'll see everyone in 20 minutes.
Thanks for having us.
Thank you.
Thank you.